We're on the video record, 11:51 a.m.
All right. Mr. Chandler, would you please continue with what you wanted to relate to me regarding Mr. O'Boyle?
Yeah, so things really got rolling in earnest starting January 27th. The first week it was very exciting. I did a seminar for a couple of activists, and Giovanni Mesa, one of the attorneys for the O'Boyle law firm, sat in on that. I actually hired the first, I guess I was the first employee for the foundation, but the second employee, a guy named Terrell Elliston. He only worked for a very short time, 2-3 days. He and I have been friends for a long time, and he just decided he wanted to go in a different direction. But I met with he and his wife. He and I went out and actually made a bunch of public records requests together. In fact, he was with me on that first audit I did in South Florida. All of my interactions, I didn't have any interactions with the board at all, except in any official capacity. I talked to Denise DiMartini early on about helping me develop a logo for the foundation, and that's when she expressed her surprise that she was on the board. But we had that conversation by phone. I still hadn't met her. I would see Bill Ring on a pretty regular basis, but just because he was there at the Commerce Group, we never really interacted much. In fact, we kind of had this ongoing running joke that when I would see him, I said, I'm supposed to be, I serve at your pleasure and, at your direction, and his responsibility, I direct you to go, go do something. I mean, it was sort of in a friendly way, sort of a nod and a wink that, they're really not doing anything. I'm doing it, which was great for me because frankly, I was very happy, delighted actually, to be accountable to somebody for the money, for what I was spending. But I was equally delighted that I wasn't really having to answer anybody about where I spent my time, what I was doing. And I was having lots of meetings with civil rights groups. I was meeting with other activists. I had meetings with the Society for Professional Journalists. I had meetings with student organizations, and felt like I was really doing what I am passionate about doing. And I was pretty much left alone. There wasn't a whole lot of, like I said, there wasn't any interaction with the board per se. I did talk to Marty when I was in South Florida, in Palm Beach. I would stay at his home. He was very generous in that respect, and I welcomed his hospitality. But also, he's very busy, and when I was in the office, the Commerce Group office in Deerfield Beach, he's very inaccessible, just because he's busy. Whereas when I stayed at his home, he would get up early in the morning, I would get up early in the morning. We'd literally, we'd meet in the kitchen and have a cup of coffee at 6 o'clock in the morning or 5:30 in the morning, and for an hour or more, it was just two of us. And I would try to kind of give him updates on what I was doing, and it was a little frustrating because he didn't really seem at all interested in the advocacy part of it. For example, I was last year and again this year, I was invited to Tallahassee to meet with Don Gates, who's president of the Florida Senate, to just kind of talk about open government issues. Last year, he asked for me to give testimony in front of a state Senate committee on government accountability and oversight. And when I was invited to go up again this year, had a really good meeting, and we talked about some proposed open government legislation. And in that conversation with Senator Gates, I told him about the foundation and my new job, and he was very positive, very pleasant about it. Senator Gates is a delightful man anyway. And I was really excited about that. I felt like a big piece of what I was bringing to the foundation wasn't just my ability to do audits and the potential litigation that came out of that, but and not just my expertise on open government, but I've also cultivated, I think, very meaningful and significant relationships with Barbara Peterson at the First Amendment Foundation, Senator Gates, with a number of other public officials, with a lot of other organizations, the Society of Professional Journalists and the Associated Press, and I have a lot of media contacts that I've developed.
Right, and the research I did on you before coming here to meet you, it appears that you've done quite a bit of work with open government, First Amendment for journalism, that you have quite a bit of expertise in that area.
A lot, yeah. And I am, it would not be hyperbole to say that I get contacted every single week by reporters. I mean, number one, I source for a lot of reporters. I spend my time digging through public records. And very often that leads to interesting, newsworthy stories.
Right.
So frequently I'm called by reporters who are asking me for leads on
Right.
stories.
You're researching for them, basically.
Very much so, yeah. Not in any formal way. I don't pretend to be a traditional media outlet. I don't care about getting credit for the story. I just want the story told. If I find some graft or corruption or some something that I think the public ought to know about, I just want the story told. So I'm frequently contacted by reporters under that set of circumstances, but also very frequently reporters will contact me saying, hey, look, I've asked for this record. They're not giving it to me. What do you think? Well, I'm not an attorney. I can't give you legal advice. I can tell you what I would do if I were similarly situated. And we sort of talk shop about that sort of thing. So I've cultivated a lot of relationships.
Right. And your integrity and your credibility are the cornerstone, I take it, of those relationships.
Yeah, the way reporters describe me is I'm 100% source. If I tell a reporter something, they can take it to the bank. I don't exaggerate it. I don't claim it unless I can prove it. I mean, I'm frequently, that's how reporters have said I am described as 100% source. And it's because I'm a straight shooter. I mean, even if people, I think even to a very large extent, public officials that I've had a fairly adversarial relationship with, I think that at the end of the day, most of them would acknowledge that, I mean, there's a reason why I win. It's because my facts are right, and I don't pull the trigger on a lawsuit unless the facts are 100%. And I think that's part of the reason that I've developed good relationships, not only with the media, but with some legislators and with people like Barbara Peterson and even some academics. So one of the frustrations I had in these meetings that I would have with Marty over coffee is he seemed completely disinterested in this. So I was trying to explain to him the significance, for example, of this. I had a dinner meeting with the president of the Florida chapter of the Society of Professional Journalists, which is the largest journalism organization in the world. And here's a guy who is the head honcho for that organization for the state of Florida, who's really eager about working on projects. And a big part of my time with the foundation was working on specific projects. So for example, I'm very interested in learning the particulars about school resource officers and what kinds of resource officers, what kind of police officers end up in that position. So for example, I've been told, had a lot of anecdotes that it's just sort of a dumping ground for bad cops. Well, I don't know whether that's true or not, but I can look at public records and find out. So, for instance, in Hillsborough County, if you look at the Hillsborough County Sheriff and the Tampa Police Department, which provide SROs to the Hillsborough County School Board, 80% of their officers have no disciplinary history, none. But of the officers who have been provided as SROs, 97% of them have disciplinary histories, and some of those disciplinary issues are very serious, including a TPD officer who is investigated for aggravated sexual battery. Well, that has the potential to be a really great story. And what I was after in doing these projects, and I had about 40 of these things, these stories showcase why public records access is so important. The SROs, for example, doesn't matter whether you're a liberal or a conservative or rich or poor, if you got kids going to public schools, you probably care whether Officer Friendly is a creep or not. If Officer Friendly has impulse control issues for beating suspects, you probably want to know about that. And I had a whole bunch of these projects, and to me, the why these are important is we can hold these up as examples of why public records access matters. And I was disappointed because the response I got was really tepid, sort of like, In fact, Marty told me at one point when I was telling him about the dinner I had with the SPJ, because they wanted to collaborate on these stories. It was sort of like, why are you telling me about this? I don't care.
And you expected that would be a big part of the foundation's?
It was a big part of it. That was the deal. Yeah, absolutely. That you know, getting a paycheck's nice, and having lawyers to litigate is nice, because I need lawyers to litigate when I want the records and to enforce the public's right to know. That's all great. What I care about are the resources to work with groups like the Society of Professional Journalists or student groups like Dream Defenders, to empower them in their membership to do public records access. But I also want to work with the media to develop these stories that continue to show the public why it matters that we have access to records. It's constitutionally protected civil right, and it's really important. All the rest of the stuff with the foundation was entirely ancillary to me. I got it. I understood that, you know, I understood that Marty wanted something out of this, and what Marty wanted out of this was cases for his son's law firm. Okay, fine, as long as that's a byproduct of what I do. And that was in February when Marty and I had these meetings in his kitchen over coffee. Was sort of the beginning of me really feeling like maybe there wasn't any pushback. He wasn't keeping me from doing it, but he just didn't seem interested in it, which at that point, it was just sort of disappointment. It wasn't really a concern. It wasn't like he was saying, I don't want you spending your time doing that. It wasn't telling me that I couldn't take reporters to dinner. It wasn't that I couldn't meet with student groups. It was just he didn't seem to really care.
Mm-hmm. So this is in February.
This is in February.
So that was let me see, I don't want to put words in your mouth. Was this, in the business, we refer to red flags. You may have heard that. Lawyers see red flags.
Yeah.
Was this something that you saw as a red flag?
No.
Raised your concern at all?
No, I wasn't concerned. It was disappointment. I would have been concerned if he had put the brakes on it. He wasn't putting the brakes on it. He never said you can't do it. It was just, I don't really care. Don't bother me with the details, was sort of his attitude. Okay. In fact, I sent him a number of emails when I after I had my meeting with Senator Gates in Tallahassee. I sent him a very detailed email explaining why I thought this was important and some of the legislation that was pending, and you know, again, his response was sort of tepid. I had a meeting with Barbara Peterson at the First Amendment Foundation about coordinating our efforts and working together, and again, his response was just sort of tepid, like he didn't really care about that, which I found puzzling and personally disappointing, because I felt like Barney was sort of a true believer and really cared about the open government part of it, and that made me feel like what he was really interested in was litigation. But again, I don't care as long as you don't interfere with what I'm doing.
Right. And you have the complete discretion that you agreed upon to
Correct.
run it properly.
Correct.
Now, did you get any, I don't want any lawyer-client communications that are advice, or
Sure.
you're seeking advice or receiving advice, but did you get any complaints from anyone that they were having ethical concerns, including any lawyers in the firm or any staff, or did anybody ever contact you in February with regard to any
Yeah, when I, because in the memorandum of understanding I had with Marty, I say with Marty, technically I guess with the foundation, although, like I said, I don't think anybody ever signed it. At least I never got a signed copy of it, but I negotiated it with Marty. You know, part of the deal was I could no longer do any pro se litigation. And I had, when the foundation was created, I had several cases. I can't remember if I had filed them pro se or not. I don't remember, but there were several cases that needed to be litigated.
Well, you're the plaintiff.
Well, I was a plaintiff personally, and I gave those to the Oval Law Firm for several reasons. One, it was convenient. I was down there a lot, and I was, you know, it was sort of the beginning of trying to develop a rapport with the other attorneys, who I came to like very much, by the way. Merritt and Hannah, who I have tremendous respect for, and for Giovanni Mesa. And neither one of them had done any, I don't think they had really done any public records litigation, so it was also sort of a teaching opportunity to kind of, you know, not only did I want the foundation to have a particular culture, which I wanted to control, but I also wanted to cultivate the culture of the firm to the extent that the foundation was its client, and we were its principal client. My understanding was that we represented virtually, not all, because Marty was also a client, but we represented the vast majority of the cases that the law firm had. And I am very, very insistent that I want things done a certain way, for a whole lot of reasons, not the least of which is I don't like to lose, because losing, bad facts make bad law. And I don't want to litigate cases unless we're going to do them the right way. And in the beginning, Merritt Hanna was the attorney who was representing me personally in a number of cases, and I was very happy with her.
Okay, well, keep in mind, anything you discuss in terms of her advice representing you, you have the right to
I
keep
understand.
confidential, or you
I
can
understand.
waive.
I'm more than happy to waive it. And I don't know that we're really going to get into the particulars of anything that would be privileged anyway. For example, in one of the cases that the firm was representing me on, where she was the attorney of record, I actually sat in with her when she was talking to opposing counsel for the purposes of settlement. Frankly, I wanted to hear how she did on the phone. This is somebody who presumably is going to be representing me, or is representing me, and is going to be presumably representing the foundation on a lot of cases, and I wanted to get a sense of what her style was. And I was very pleased. I thought she did a really fine job. She was very detail-oriented, and she seemed very committed to doing things ethically. In fact, one of the very first things I did when I went to work for the foundation was Jonathan O'Boyle came to me and said that Merritt Hanna had expressed real reservations about being involved with this. And when I talked to her, and I had
This, you mean the foundation?
doing public records litigation, yeah.
Okay.
Because her perception, I think understandably, was sort of, we're just gonna be going around engaging in gotcha litigation. I mean, I think her attitude was sort of, this is like slip and fall stuff. And I met with her, just the two of us, at one of the conference rooms at the Commerce Group. And it's the first real conversation we ever had. And by the time I got done talking to her, I think she was really sold on the concept of what I do. And she expressed to me that as long as I was involved, she wanted to be a part of it. That I was very flattered. She said, I want to represent the White Knight. I mean, she felt like I was really, the reason I was doing it, my motives were pure. She didn't feel like everybody else's were, but she was, and that we were sort of joined at the hip at that point. I was very happy with her representation, and she and I exchanged a number of emails, I think beginning in February, where she felt like she was being pressured by Jonathan to make monetary demands in some of my cases that were beyond what were reasonable.
Beyond the time that was spent.
Yeah, all I was asking for, my arrangement with the foundation is I would not be involved in any other money-making opportunities or any money-making ventures. So I was not seeking anything out of these lawsuits. I wanted nothing. I didn't want a penny out of them.
The ones where you were plaintiffs.
Where I was a plaintiff, that's
Right.
right. And so all I was asking, and I always do the same, I make three demands whenever I'm involved with public records litigation or open government litigation. First, you got to produce records without further condition. Secondly, the defendant has to take some kind of meaningful remedial action so I don't have to sue you again. This isn't about seeing how many times I can sue you. It's about you actually making the records available to the public. They have a right to see it. And third, I want to be reimbursed for my attorneys to be paid their reasonable attorney's fees pursuant to 119.12.
And that's their actual time and the value of their services. This is not a contingency case in terms of there's no money being obtained from the government. They just pay the fees, correct?
Yes. And I'll make a distinction here. I personally, because this issue is going to play into some of our further conversations today, when I've been the plaintiff in public records lawsuits, when I have an attorney, we will make a demand, those same three demands: produce the records, take some meaningful remedial action, and it's surprising how reluctant public agencies are to do that, which seems like sort of the, let me help you fix the problem so we don't have to do this again. And then I want to be reimbursed on my attorney's fees paid. There have been instances where where defendants, particularly state contractors, who have been very recalcitrant to correct problems. I may not make a demand for my attorney's fees. I just may make a monetary demand, period. You know, you want me to give up my right to be vindicated in court if you'll produce the records and take remedial action. I'll dismiss the case for $2,500 or $5,000 or whatever number.
Where your fees are at least that much.
No, where my fees aren't that much. I mean, I have done this where I have been pro se, and I've had defendants who've said, we want you to dismiss the case. Well, that's great. I want you to obey the law, and I want to be vindicated in court. We're having a settlement negotiation, and I'm very blunt. I'm asking for money that I'm not entitled to. I want you to pay me $1,500. You want me to dismiss the case, pay $1,500. And the defendant's like, well, you're not entitled to that. You're right, I'm not. That's why it's called a settlement negotiation. We're talking about things we're not entitled to. You're not entitled to have me dismiss the case. The only thing that either one of us are entitled to at this point is due process. If you're going to ask me for something you're not entitled to, I'm going to ask for something I'm not entitled to. I have no problem with that as long as that's what's being communicated. As long as you're making it very clear, I'm not asking for something under the pretense that I'm entitled to it. I'm saying, I'm acknowledging, I'm not entitled to this. This is consideration. You want me to do something, then I want you to do something for me. When it comes to,
And that would go to the plaintiff, that money, not to the law, not to lawyers.
yeah, well, I'm talking about when I've done that as a
Pro se.
Pro se. Frankly, these and I don't. This is not with public agencies. You understand, public operated agencies, because that's tax money. Those taxpayers are paying that money. I got a real problem with that. When you're talking about a for-profit corporation who has a $1 billion contract with the state of Florida, and they have violated their contract and violated the public's right to know, I'm not even slightly bashful about saying, yes, you want me to dismiss this case. Your defense is we didn't know. We didn't realize we were subject to the Public Records Act. Well, guess what? I did you a big favor by bringing it to your attention, and I did it at my own personal expense. I'm completely unapologetic about saying, yeah, pay me $1,500 or $2,000 or $2,500. That's one thing. It's something entirely different for an attorney to make a demand and to suggest or outright claim that the demand is for attorney's fees when they're actually asking for more money than what they've earned. The issue that Merritt was having, and the issue that I shared with her, we shared the same concern, was if the O'Boyle law firm at $350 an hour has billed $4,000 and they've got $500 in expenses, why would you ask for anything more than $4,500?
Of a government agency.
Or of anybody,
Right.
of anyone. Now, if you're suing a private contractor, which these cases were where I was being represented were against state contractors, it would be fine if you wanted to make a monetary demand of $6,000 and my legal fees are $4,000, as long as you present it that way. As long as you present it as my client, Mr. Chandler, is willing to settle the case for a monetary payment of $6,000, out of which he will cover his expenses.
And in that scenario, the plaintiff would get anything beyond what the fees were, I take it. That wouldn't go to the lawyers.
Yeah, well, you would think, right? I mean, that was, and this was, and thankfully, this really didn't enter into the equation, at least I didn't think, because I wasn't seeking to get anything out of it. I don't want any money out of it.
As the foundation.
As an individual.
As an individual, okay.
Right, I think there were 3 or 4 cases against these private contractors.
And
All
the
I
O-
wanted
And
was,
the O'Boyle law firm was representing you regarding those.
that's right,
And that was done through Hannah, you said?
Merritt Hanna.
Merritt Hannah.
And Merritt,
All of them?
I don't remember. I can't. I think they were, but I'm not 100% sure of that.
Okay.
The problem, the pushback that Merritt was getting, as I understood it, and she and I talked about this on the phone a number of times. We exchanged emails about this. Was she was getting pressured to make higher demands, and my response was, why?
Who was she getting pressure from to make that?
Jonathan
O'Boyle.
Yes.
Now, was he in the Commerce Group offices full-time whenever you were there, working at the O'Boyle
Yeah,
law
he
firm?
was living at his mom and dad's house in Gulfstream, and he was there, yeah.
Full-time?
Yeah.
So he worked out of the the Commerce Group offices where the law office had its room
Yes,
on a full-time basis.
yes,
And she told you that Jonathan was putting pressure on her to ask for more in fees than had been earned.
yes,
How many times did she communicate that to you?
repeatedly.
And that was in February.
Yes. And she, you know, my response to her was, it's, you know, I understand that you guys want to get your reasonable attorney's fees, and I'm all in favor of that, and that's gonna be part of our settlement discussions. I couldn't care less about you guys getting a penny more than that. That's not my interest. And it's frankly not your decision to make. It's not Jonathan's decision to make. It's mine and mine alone. I'm the client. I get to make that decision. That's the way it works. You know, frankly, if I said that I was willing to settle the case for no attorney's fees, that's my choice to make. It's not yours. You guys took this case on a contingency. It is what it is.
Contingency meaning they wouldn't get their fees unless they were awarded.
That's right.
Not
And-
a percentage of any recovery.
That's right.
And there was no fee agreement on any of these cases.
That's right, and which again, I chided them about that repeatedly. Look, guys, we gotta have these fee, because if you get to a fee hearing and we don't have a fee agreement, if I were opposing counsel, I'd be arguing that you're not entitled to anything because the Florida bar is really clear about this. On any kind of a contingency fee agreement it shall be in writing. It's not,
Right.
you don't have any latitude there.
Right.
As a result of Merritt expressing, and again, this is what she
So you made it clear to the O'Boyle Law Firm through Merritt that any contingency fee had to be in writing.
Yes.
You-
And I
which is
communicate-
clearly a bar requirement.
I communicated that to Ryan Whitmer, I communicated that to Jonathan O'Boyle, I communicated that to Giovanni Mesa,
And it was just ignored.
it was ignored. So as a result of my support for Merritt's position, I think she was emboldened to sort of stand her ground with Jonathan, and as a result of that, she was removed from the cases. Without my consent, without my knowledge. I just found out after the fact that she's just been taken off the cases, and, you know, Ryan Whitmer was gonna handle them. And it was
And who told you that was being done?
Merritt.
She told you she had been removed?
Yes.
And by Jonathan or
Yes.
by Ryan? By Jonathan?
Yes.
And Jonathan appointed Ryan to handle the
Yes.
cases? And what did you do when you learned that? This was in February?
I believe it was in February. I was annoyed by it. I was frustrated by it. I mean, it wasn't one of those things. It wasn't a complete deal breaker for me. It was, my perception was this is just young attorneys not thinking very clearly. Not Merritt. I'm talking about Jonathan in particular. And there, I also kind of had the feeling that there was sort of this little bit of a power struggle. I think he perceived that he was the one that was in charge, and if he wants to be in charge of his law firm, that more power to him. But I'm the one that's in charge of the foundation, and I'm the client. So when it comes to the litigation, and in these particular cases where it was me personally, I know who's in charge. It's me. It's not the attorney. I'm the one that's calling the shots here. The attorney is a technician who provides advice. That's it. I get to make the decisions about litigation strategies and what we're going to demand for settlement. And again, I am far more interested in the first two settlement conditions than I am the third. You got to produce records without further conditions, and you have to take some meaningful remedial action.
So who were the defendants in these, you said about 3 cases that you were the plaintiff in?
Yeah, and there were great facts. Every one of the facts were just gold. First Coast Advantage is one of them, and the other ones.
What county?
In Duval County.
Okay.
They're a ACA contractor.
ACA contractor?
Yeah, I'm sorry, the Agency for Healthcare Administration.
Okay, and where was that?
Well, ACA's in Tallahassee, but the First Coast Advantage is in Duval County.
Were these all 3 filed in Duval County?
I think it was First Coast Advantage, and then it was Memorial Healthcare Group.
Where was that
There's
case filed?
Duval County. That's another one with just golden facts. Northwest Behavioral Health. And again, I stand by the facts of these cases, and to my knowledge, the cases are being handled ethically.
Yeah, they haven't been settled. You didn't let them settle them for more than the fees were.
That's exactly right.
You stopped them.
Yeah, we aren't going to do that. So that led to.
So all three of these are in Duval County?
I believe they are. Yes.
Okay. And you're the named plaintiff?
Yeah. Yeah. With just, these are. I would say that the facts of those cases, that's very typical for the work that I do. I mean, you walk in, you make the request, the contract clearly says that they're going to have to produce a record. You ask for a record that you know exists because it's required to be created in the contract. You ask for it, they tell you no. Sometimes, I've actually had instances where they call the police to have you removed for doing nothing more than politely making a public records request. I love those facts.
Right. Now, you don't have to disclose this. I don't believe it's privileged communication, but obviously you're the client. It's your call.
Yeah.
Do you have an oral agreement with the Boyle Law Firm as to what the hourly charge is for different lawyers on these cases? Or they just charge what they think is fair?
I believe that Ryan, who's handling them now, because Merritt left the firm, largely over these issues. I think he charges $250 an hour. Merritt, who is a much more seasoned attorney, much more seasoned attorney, I think was charging $350 an hour.
So you agreed to pay $250 an hour for those cases?
I didn't agree
orally?
to pay it. I agreed that
That was a reasonable fee?
a reasonable fee, yeah.
Okay.
Yeah, just their fees and expenses.
Are there any writings that memorialize that, or just a conversation?
No, in spite of my suggestion, urging
Okay.
that we should have it in writing, it hasn't been.
So, okay.
So things. Back to the
You're starting to see some red flags.
That was a concern for me.
Right.
And it wasn't that big a deal to me at that stage of the game as far as the involvement of the foundation, because the vast majority of the cases that we had at that time were against publicly operated agencies, municipalities, state agencies, not contractors.
And as I understand it from your description, you liked Ryan, you considered him charming, and the fact he took over the cases didn't offend you from the standpoint that you had respect for him.
Yeah, it offended me that Merritt had been removed because I liked what she was doing. I thought she was very competent. More